All right. Good morning and welcome, everybody. We really appreciate you taking the time out of your busy schedules to join us today. We want to give folks another minute or two to hop on. And while we wait for others to join, I'm going to set the stage here in a little bit. So when it comes to public sector labor laws, where do unions have the most power and where is their influence waning? How does your state rank in the battle for worker freedom? Those are the questions we'll be answering in today's webinar. And with that, we can go ahead and get started. So again, good morning. Thank you all for joining us today. My name is Josh Kaib. I am the Senior Director of Marketing and Communications at Commonwealth Foundation. And today I'm joined by David Osborne, Commonwealth Foundation's Senior Fellow for Labor Policy, and Andrew Holman, who is our policy analyst. And together they co-authored our latest report, The Battle for Worker Freedom, Grading State Public Sector Labor Laws. And they're here today to break down the key findings for us. Before we get started, I'd like to outline some ground rules for the call. My comments are on the record. We will be sending you all the full report as well as our analysis presentation after the call. All of that is on the record and can be used in your stories. And David and Andrew's comments are also on the record. We're planning to take Q&A at the end of the call. You can submit your questions throughout today's call by using the Q&A function on Zoom. You should be able to find that button on the bottom bar of your Zoom window. So feel free to submit those questions throughout the presentation, and I will read them out at the end when we have our Q&A section. The report delves into the major changes in power throughout the United States where unions are consolidating authority by altering public sector labor laws and where they're losing influence to recruit and retain members. The report provides a letter grade for each state's labor laws, evaluating criteria from collective bargaining to right to work. Now, I will now turn the call over to our policy analyst, Andrew Holman, and our senior fellow for labor policy, David Osborne, for their presentation and analysis. As a reminder, Andrew and David's remarks are on the record.
Hi there. Good morning. Thanks for joining. On this first slide here, you'll see a website. That's where you can go to not only find this report, but to use some of the online tools, including a comparison tool that you can look, one state versus another to see what the differences are. Andrew, can you move to the next slide? Okay, so some background. So this is our flagship report published every 2 years in a series of reports that document public sector labor law and trends in state and local governments across the country. The two other reports in this series are How Government Unions Fund Politics Across the Country, which we published in December of 2023, and Examining Union Membership in State Government, which we published in March of 2024. Andrew Holman and I are co-authors of these reports, and we'll be giving you a rundown of the big one today. So in this particular report, we closely examine state laws that strike a balance between empowering union executives on the one hand and empowering the workers they're supposed to be representing on the other. We also take a look at national membership trends and major developments in litigation over worker freedom. The value that we add to research, sort of anything you Google online in this area, is that we look through the lens of workers instead of union executives, and we look through the lens of taxpayers instead of the union interests. There were a few reports that actually came out around this time, one from Harvard that I think illustrate this very well. So next slide, Andrew. So the importance of public sector labor law here. Why focus on public sector labor law? Well, the reality is that public sector unions are really a major player in both policy and politics. Think teachers unions, the NEA and AFT, state and local employee unions like the SEIU and AFSCME, and police and fire unions. They all have very loud voices in state capitals, and they have a profound influence on national elections. So think about some of the stories you've heard on Kamala Harris and Donald Trump on the other side trying to court union interests. To understand these unions, really, you have to understand that the power structure is built on the local and state levels. So that's why we're focusing. At their root, public sector labor laws are a combination of various legal privileges to unions These are entities that were once organic, unregulated, strictly voluntary. But today, most state labor laws regulate the process of organizing a particular workforce and handing over something called exclusive representation to a union, essentially a monopoly right to represent workers in a particular workplace. That's true even of workers who voted against the union, don't want to be represented by a union, and will never become members of a union. Unions now are highly regulated. They're highly embedded in state and local governments, and they've secured additional legal privileges, such as the right to strike, to restrict members from resigning their union membership, and have the government collect their dues and PAC contributions through the public payroll system, among many others. So what's important to see here is the immense benefit that these privileges can be in building a union's power structure. Yet, once they become powerful, the men and women that run these unions often maintain this power as a means to further their own political celebrity instead of as a means to represent workers. So the objective of our report here is really threefold. One, we want to make public sector labor law more accessible to you and to others who are interested in public sector labor reform. Second, we want to show how simple changes in state labor law can actually alter the power balance to empower individual employees, even in heavily unionized environments. Think Pennsylvania, New York, Connecticut. And then third, we want to show the importance of labor law to those who are working in other policy areas like education and fiscal policy. I wanted to make some notes on methodology before we really dive in. So first, this report focuses on labor law developments over the last 2 years. And we're looking at a combination of labor laws in every state and then assigning a grade based on a variety of factors, largely the level of freedom that's given to individual employees in that particular state labor law. We are not grading every aspect of state labor law, such as case law, administrative rules and regulations, or common practices. All things that I'm very familiar with as a labor law attorney in this area, all of which are very important, but which are always changing and are very rarely understood, at least on the global level. So we've looked just at state labor laws and then in some cases, some state constitutional provisions. And then second, when we talk about union membership, we're going to be referring to numbers that are self-reported in what are called LM2 forms. These are forms that are filed much like a tax return, but they're filed with the U.S. Department of Labor by most unions. These are self-reports, for better or worse, meaning that the unions may have understated certain information they believe is negative and then overstated some positive information. So when it comes to membership losses, which is one of the numbers that we look at here, there may be more accurate numbers out there, but we can at least say that these are solid conservative estimates because the unions have reported them. All right. So Andrew is going to start here with our key findings in the report, and then we're going to jump back and forth here discussing some of the intricacies of the report itself.
Thanks, David. In terms of key findings, I think the one that jumps out to me the most is that the 4 largest government unions, that is the American Federation of Teachers, National Education Association, American Federation of State, County, Municipal Employees, and the Service Employees International Union, these 4 unions have lost more than 100,000 members since 2022, and a total of roughly 320,000 since the 2018 Janus decision. And altogether, these membership losses represent approximately $106 million in annual dues and fees. Now, what we're seeing in states across the country is that the leaders of these unions are trying to counter these losses by engaging in aggressive organizing campaigns and aggressive campaigns to change laws. And in this respect, we've seen unions gain some ground in Illinois, Michigan, and Maryland over the past 2 years. On the other side, we saw Florida set a new gold standard for public sector labor reform, the best we've seen since Wisconsin's Act 10. And then we also saw some good reforms in Arkansas, Kentucky, and Tennessee. In terms of litigation, Janus-related litigation has slowed in the past 2 years, but public interest law firms are still successfully defending Janus rights, and they're also innovating and finding new creative ways to help employees hold their unions accountable. In terms of grading, since 2022, we've seen 3 states have significant legislative developments that changed their grades. Florida increased from a C to an A, Michigan decreased from a B to a D, and Illinois fell from a D minus to an F. So I also want to talk about union membership trends. As I mentioned, the 4 largest unions continue to suffer significant membership losses. They saw a big initial drop after Janus, and we're seeing this drop continue to happen. As I mentioned on the last slide, the 4 unions have combined to lose over 100,000 members in the past 2 years. And since Janus, roughly have lost 320,000 members and almost 380,000 agency fee payers. These losses are costing these unions financially. As I mentioned, they've lost roughly 106.8 million in annual revenue. I'm sorry, these membership losses represent roughly 106.8 million in annual revenue. And as a result, these membership losses are really driving their organizing and public policy strategies in certain states.
All right, so let's talk about Illinois. Illinois moved from a D minus to an F in our rankings. I have to say, though, if there were a grade lower than F, Illinois would deserve it. And that's because Illinois has done something we have never seen before in public policy surrounding public sector unionism. They have adopted a constitutional amendment that creates, this is new territory, but it creates, quote, a fundamental right to organize and to bargain collectively. And in case it's not clear, based on the fact that it's a constitutional amendment, it also states, and I'll just quote directly from the amendment, no law shall be passed that interferes with, negates, or diminishes the right of employees to organize and bargain collectively. So this constitutional provision, because it trumps state law and is very clear about that, it effectively constitutionalizes any union activity in this area or collective bargaining agreement, putting both of those things beyond the reach of any regulation or statute. This is an experiment that could have really disastrous implications. I mean, think about this. If the union were to come up with some collective bargaining agreement that the legislature didn't like, the legislature, popularly elected, wouldn't have any opportunity to overrule that kind of behavior. It would take a constitutional amendment to correct that imbalance. We've already seen the Chicago Teachers Union here take advantage of this. During some collective bargaining contract negotiations, they've gone well outside the scope of traditional public sector bargaining over wages and benefits, and have made some outrageous demands like affordable housing, homeless shelters and schools, all electric bus fleets, and abortion care funding. And look, regardless of what you think about those items, they're well outside what we've typically trusted unions to bargain with public officials about, and typically and well outside of those bounds in a way that I think even union members who are supportive of Illinois, of the Chicago Teachers Union, may be very justifiably worried about. All right, Andrew, Michigan.
Yeah, so Michigan's another one of those states that we saw their grade decrease. They moved from a B to a D. And really, since the 2022 election cycle, the lawmakers in Michigan have completely upended the state's public sector labor laws. Perhaps most notably, they overturned right to work for the private sector employees in Michigan, but they also became the first state to legislatively remove paycheck protection, which makes unions responsible for collecting their own dues and fees rather than relying on the public payroll system. In addition to this, they passed legislation to help unions recruit new members by requiring public employers to furnish the unions with employees' personal information. Essentially, what that means is the unions now have access to every employee's personal contact information, including home address, personal email address, phone number, etc. And finally, they expanded bargaining to new groups of public employees, including graduate students and public school administrators. Now, I think one of the most interesting developments out of Michigan was they passed legislation kind of in conjunction with overturning the private sector right to work. This legislation permits unions to force employees into fair share agreements to keep their jobs. Now, this is unconstitutional under Janus, but what this law does is creates a trigger that will go into effect if either the Supreme Court overturns Janus or limits it, or if there's a federal constitutional amendment that supersedes Janus. This is something that we've seen in contracts before, but never really in state law. So I think that this might be a trendsetter in certain ways for unions in these states where they have control in an effort to further that control if anything were to ever happen to Janus. Also wanted to talk about Maryland. They earned an F grade and their grade did not change. But I think what Maryland did is they're really, what they're doing shows how union officials are reacting to membership losses. They enacted several pieces of legislation that further expands public sector collective bargaining into new workplaces and to new groups of employees. And they also created a new tax deduction for union dues that incentivizes members to pay membership dues. Maryland actually already had one of the highest union membership rates in the country, and this is only increasing. And developments like the ones in Maryland, it's, what we're seeing here is government union executives really pushing to make up for those membership losses post-Janus.
So as Andrew shared earlier, Florida has set a new gold standard here. They've enacted a series of reforms over the last couple of years that protect public sector workers and make union officials accountable. It's a whole package of reforms. I'll go over a few here that I think are most important. One is something called recertification. Recertification is a concept that came from Wisconsin when Scott Walker championed Act 10. Recertification at its root allows public employees to re-elect their unions periodically. And I think this should go with this should be an easy reform, but the reality is in most unionized states, unions very much oppose recertification. They don't want to have to run for re-election periodically. And as a result, in states like Pennsylvania, Illinois, New York, Connecticut, California, many unions have been in place since the 1970s without ever having to run for re-election. It actually means that most of the people, if not all of them in a particular workforce, have never actually had the opportunity to vote on that union. It simply retains its certification from year to year without challenge. Well, Florida joined Wisconsin and Iowa in enacting recertification requirements that would require, in Florida's case, any union whose membership drops below 60% to have to run for re-election. And this is a secret ballot election run by the state. It's not it's a safe system that I think accurately reflects the level of support. We've already seen a bunch of unions fail to even file for re-election because they know that they'll lose based on their membership numbers. Some of them have 0% membership. So this ends up removing a union that really never had majority support to begin with, and helps employees, if they wish, to elect a new union or to go union free in their workplace. Second one is paycheck protection. We've mentioned that terminology already a couple of times. I'm going to go into detail on it in the next slide, but for now, just know that for many years, Florida has been in the business of collecting union dues and PAC contributions and is now out of that game. All it does is require that the union would have to collect those monies on their own. And then third, there's a disclosures to new members now required under Florida law. So when the union comes to recruit a new member, now they have to provide a form that informs the new member of their right not to join the union and not to pay dues or fees to the union. It also requires the union to disclose certain financial information about the union, including dues amounts and the amount that that the union officials make from year to year off of membership dues. So these are compelling reforms that I think help people make a good decision at the outset as to whether or not they'll join a union. And then as part of that, they have the right to resign at any point, something that's kind of rare in state law these days. Many unions keep their membership numbers up, not by proving their value, but by restricting the right of a public employee to leave the union at any time. So Florida moved from a C to an A here in our rankings. Second one is paycheck protection. So I mentioned this with Florida. Andrew mentioned it before. Paycheck protection has proven to be a super popular reform in this area. There are a couple different types of paycheck protection. One is called, it would restrict the state from or local government from collecting dues, and another form might restrict them from collecting PAC dollars. And of course, there are some that do both and restrict the state from doing either one of those things. All it does is make the union responsible for collecting their own money here. And there's a U.S. Supreme Court case called YSURSA, YSURSA, versus Pocatello Education Association from 2009 that confirmed that the government has no responsibility to subsidize union political activity by collecting union money. This is a simple reform that protects public employees who often don't see their dues or fees coming out of their paycheck to begin with. And it focuses union executives on having to go and prove their value to union members because union members will actually see that they have to pay this amount. Of note, I think in this area, two of the states who enacted this reform recently, you might add Florida to this as well. They've coupled these reforms with a pay raise for teachers. I think basically to prove to them that the state in making these restrictions is actually restricting unions, not workers themselves. And if they can reward workers, they'll do it. And they've proven it by putting their money where their mouth is here.
I want to talk about some other notable trends that we're seeing. First and foremost, the public employee personal information legislation that I spoke about with Michigan, that's becoming more and more widespread. It's now in 14 states, and this is something that, one, opens public employees to unwanted solicitations on the union's political or organizing objectives. And two, it also puts their information at risk when the union holds a employee's personal contact information. They have to do so responsibly. And we saw with a case in California where unfortunately the union was a victim of a cyber attack. And as a result of that, all of the employees' personal information was taken in that cyber attack. So this legislation is not only, annoying to employees with the solicitation, but it can also be somewhat dangerous if their personal information is disclosed. Secondly, we're seeing tax incentives for union dues becoming more and more widespread. 3 states in the past 2 years enacted this type of legislation. Delaware and Maryland offer a tax deduction for union dues, so that's money taken off your taxable income, whereas California actually offered a tax credit that is money taken off the taxes you owe. So California provides quite a big benefit, but Delaware and Maryland also have benefits, and we're seeing this type of legislation get proposed in other states, such as Michigan. In union strongholds, lawmakers are extending collective bargaining privileges to new groups of employees, including legislative staff, public university student workers, and supervisory employees. We saw this in Michigan. We saw this in Maryland. It's happening in California, Illinois, Washington, those type of states. And this is really an effort to recoup membership losses post-Janus. Unions are also continually attempting to overturn restrictions on the public sector bargaining in states like Georgia, Virginia, North Carolina, and Texas. Virginia, they did so successfully in 2020, I believe, extending collective bargaining at the local level. They're trying to do it at the state and municipal level as well. And then in a state like North Carolina where bargaining is prohibited, they're also making efforts to overturn that prohibition. And finally, outside of Florida, we saw 4 states introduce legislation that would provide for regular union recertification elections. I think I speak for David and I both when I say that this is pretty much the best reform that you can get. It really allows employees to directly hold their unions accountable, and we're happy to see it spreading to other states.
We did touch a little bit on litigation in our report, and we counted since Janus in 2018. It's a Supreme Court case that held that unions couldn't charge non-members fees for the privilege, so-called privilege of being represented by the union. Since that decision, there were about 218 that we counted lawsuits involving those rights and what they meant, whether they applied to certain state laws. It's a relatively common phenomenon after a Supreme Court decision. Got to figure out what it means. So about 218 lawsuits trying to figure out what Janus means, whether it was retroactive, for instance, since Janus. Many of those cases have now come to a conclusion. Some of them are ongoing. Many of them were settled. And so the reason that we wanted to touch on that is that some of these decisions have a profound practical effect for workers on the ground. So if they're settled with the union, that means that the union has basically refunded union dues, or at least observed whatever the Janus requirements are before the lawsuit was ultimately revoked. There were also some decisions that went in employees' favor, many that were dismissed. So many of the courts were not yet willing to extend Janus to new situations. But we also wanted to touch on some of the lawsuits that didn't really have anything to do with Janus. I'll give you 4 examples, but there are many others. And I have to say that many public interest law firms are taking some very creative measures to try to protect public employees from union overreach. First case here is called Gilmore versus Galeo. It's out of Arizona, and it involves something called release time, where unions are basically granted the privilege of taking certain employees out of the workforce and putting them to work full-time for the union while still getting paid as if they were a public employee. That's been ruled unconstitutional in Arizona as basically a gift, a publicly funded gift to a private entity. So our Arizona Supreme Court has already rendered that decision. Pretty new, though, maybe a couple months ago. Another case called McFetridge. This is litigated here in Pennsylvania over the duty of fair representation. That's a duty that goes back to the 1940s. Unions owe basically a fiduciary responsibility to their members. And McFetridge is one case that's raising that as a potential barrier to some of the union overreach. Another case called Newman versus Elk Grove Education Association. This one's in California, and it's only recently been filed. It alleges that the union has breached Title VII of the Civil Rights Act. This is typically something you see filed against an employer, but it also applies to a union. So in this case, the union has actually created a structure within the union that requires people to be BIPOC, basically a racial minority, in order to hold a certain position as a member of the union, or as an officer of the union. And then finally, there's a case that's on certiorari to the Supreme Court. It's called Goldstein versus Professional Staff Congress. It's out of New York, and it challenges the concept of exclusive representation, and more specifically, perhaps, the New York state law's version of exclusive representation, under which a union basically can refuse to represent. It's called exclusive representation, but a union can still refuse to represent an employee on the basis of their membership in the union through arbitration and grievance proceedings. That's a new twist on exclusive representation that basically enables the union to force people at the threat of potential adverse action to join the union, or else face the consequences. So it's probably something that is unethical, even if it's not illegal, and that most states have not adopted.
So I wanted to talk about the most important things to take away. We're seeing that as union membership continues to decline, public sector unions have become even more aggressive in pursuing public policy changes to boost their power. Over the past 2 years, we've seen this in Illinois, Maryland, and Michigan, and these three states have enacted several reforms that significantly boost union influence on government operations and the political process in these states. Meanwhile, on the other hand, we're seeing lawmakers in Florida, Arkansas, Kentucky, and Tennessee enacting some of the most transformative public sector labor reforms of the past decade, and really working to protect taxpayers and help workers hold their unions accountable. And in terms of we mentioned this in the intro, the implications of this in other policy areas. In Florida, union influence is limited. The economy is booming. It's one of the fastest growing states in the country. And these new union reforms are going to help keep government unions in check, empower individual employees, protect educational choice, maintain low tax rates, and really just keep Florida an attractive, affordable place to live. In contrast, you see in Illinois with the constitutional amendment that's going to restrain employees' freedom, drive up government budgets, and force officials to raise taxes in what's already one of the highest tax states in the nation. And as a result of this, they're going to continue to lose residents to places like Florida. So really, in a sense, public sector union or public sector labor policy is kind of at the root of all of the battles over education and fiscal policy. And I think it's important to look at how states are combating the influence of unions and how some states are giving in to the influence of unions.
All right. Thank you, David and Andrew. I appreciate you walking us through all of that. We're going to now open the floor to questions. So if you do have a question, feel free to drop that in the Q&A box. That is at the bottom of your screen there next to raise hand and more. And then one other note is if you would prefer to take any questions offline, you, of course, can reach out to me personally after the call by text or email. My number is 412-716-5437. That's 412-716-5437. And I'll just note, I'll be in touch with you via email following this with the presentation. And you can, of course, feel free to correspond with me after I send you that as well. So our first question in... has there been any other reasons aside from Janus that led to declining union membership?
I've got a couple thoughts on this, and Andrew may as well, because we've also done a report on trying to gauge union membership, at least in state governments, as a proxy for union membership overall. So one of the factors that may be at play is some state governments are retracting, some are privatizing. And as a result, the overall workforce in some states has declined. We see this in particular where after the pandemic, states have found other ways to do business. So that's one potential answer to that. Another is that there are demographic changes. People retire, new people come on, and it may be that people who are younger, in Gen Z who are just joining government service, simply don't see the same kind of value in unions that perhaps older generations have. That may be part of it. I don't know that there's been a whole lot of research into the attitudes on Gen Z. They tend to be more favorable, though, to the concept of union membership. This reflects a broader trend. Gallup asks these questions a lot. Do you favor union membership, or what do you think of unions? People report relatively high sense of favorability towards unions, and yet many of them in practice refuse to join. So take that for what it's worth. Andrew, anything else you'd add to that?
I agree with what you said, especially about the declining state jobs. But I do think that Janus is definitely playing a big role in this. And I think, after the decision, I think more and more people are kind of becoming aware of how their dues are being used and what those dollars are being put towards. and they're kind of saying, I'm not sure if I want to be financially supporting my union.
Yeah, having litigated before and after Janus, you can see why. So Janus said that people didn't have to pay a fee to the union, basically meaning that funding the union was inevitable before Janus. And in that environment, someone might choose to pay dues and join the union. Yet now, if one can go union, if one doesn't have to pay the union at all, you might take advantage of that. So that's kind of the economics of Janus.
All right, now to our next question. This is about Louisiana. Can you speak at all on the bills proposed in Louisiana, which failed to pass? What might the future of legislation look like in public sector labor law in Louisiana? Any insights there?
Great question. We were not personally involved in Louisiana, but we had done some research on this and followed the bills as they moved through. There were a whole range of bills, everything from outlawing public sector bargaining altogether, down to some of the reforms that we've talked about today, recertification and paycheck protection, some relatively easy, true and tried reforms. And the sense that I got politically was that the governor had pushed these measures early on, given the legislature a prime opportunity to get them passed, and the legislature simply waffled, didn't understand that public sector unions are going to white knuckle, hold on to anything that they've got, and refuse everything as if it were the end of the world. So that's what unions did. They came out in force, pushing up against these reforms, even though they were largely very reasonable reforms, and the legislature just didn't wasn't up for the battle. As I understand it, they all want to try again, having learned what they've learned, and perhaps to focus on something like recertification or paycheck protection, something that may be more reasonable to defend in the court of public opinion.
Excellent. Next question. Can you speak to the power of unions within politics? And do you see any socialist undertones in the leadership of unions? I guess speak to the political and ideological aspects of the public sector unions.
Well, look, unions, they call it collective bargaining for a reason. There's a collectivist mentality. And as a result, you can hop onto any website and see a pretty strong financial and ideological overlap with some of the leftist causes in America. In fact, unions tend to support Democrats, not just slightly, but overwhelmingly. So something like 96% of union political spending goes to Democrats, not Republicans. And many are on the leftist fringes of the Democratic Party. We've got all sorts of infighting in unions about how to express this externally. So if every year the unions have conventions at which some of the most extreme leftist causes are going up against some of the what the media might call more moderate leftist causes. In reality, you can cruise around some of the resolutions that were offered at these meetings. They're all pretty extreme from a global perspective. Andrew, would you add anything to that?
Yeah, I'll just add, we did a great report on how government unions fund politics in the 21-22 election cycle. We put that out in December of 2023. I think that could be a resource to kind of fill in some color there. And we're planning on doing it again for the 23-24 election cycle. So be on the lookout for that in the next year or so.
Absolutely. Got a few more questions here. Any sense of how workers feel about their dues going to political donations in such large amounts? Anything that you would kind of comment on that?
So one of the biggest complaints that we get from public sector employees is that unions are more politically engaged than they feel comfortable with. even if they basically agree with the political leanings of the union, they feel like their union should be more focused on collective bargaining and benefits, rather than on the sort of the pet political causes of the union leaders. It also creates a certain amount of division within the union. So I mentioned what goes on at these national conventions. There have been some times where, for instance, the union has made resolutions on topics like abortion. Most recently, they've introduced a lot of resolutions on the Israel and Gaza conflict, and none of these are issues that seem to relate to what it is to be a teacher, for instance. And so many of the members come home feeling like, gee, my political union, my union really took a stance on these political matters that has divided the workplace rather than unified it, and they feel uncomfortable about that. And I'll add to that one of the things we found in our research on political spending was that union dues also go to politics. So politics, unions will often give you the line that they do not spend union members' dues on politics. That is absolutely false. In fact, 60% of their union political spending is actually coming directly from membership dues. They can use that money. They can't give it directly to a candidate in most states, but they can use it to do super PAC type activity, issue advocacy, and give it to other C3s that are doing progressive, that are leading the progressive charge. So I think union members, regardless of where they are on the political spectrum, have good reason to be concerned about the way that the unions are spending their dues.
Yeah, and I'll just note, I'm going to put this in the chat, which is for everyone to see. This is the link to that report that Andrew had referenced, which was his report on government union PAC spending in 2023. And if there's other links that we want to share, Andrew, if there's other things that you think would be good to share with folks, let me know. I can include that in my follow-up with folks.
Will do.
Excellent. Were any of the report's conclusions surprising to either of you? Anything that you didn't expect to find, or maybe something that happened that you didn't think was going to happen in any states?
We should both hit on this, Andrew, but I guess I'll start. I'll say that that as we looked, if you go through the report, the last section of the report is a state-by-state breakdown. We really did a deep dive on each one of these states. If the overarching theme, I think, is that the unions have really responded to the membership losses since Janus to try to drive up their membership. I'll mention just two states where I think that's been especially egregious. One is Hawaii, where not only do unions now get automatically from the state members or public employees' home addresses, telephone number, cell phone number, mailing address and home address, personal email address. They also get their social security number. And one of the reasons why the union wants this is to make sure that they've got the right person when they're trying to recruit, and to do collections if they refuse to pay membership dues. So handing over a social security number is something that we've often seen, as a proposal for a collective bargaining agreement. Sometimes the state or local government does it as a favor to the union, but this is the first state law I've seen. And then another is New Hampshire, where unions have bargained for the right. This is relatively common in union-friendly states. Bargain for the right to have one-on-one time with each new employee when they come on board. But in New Hampshire, they bargained for they actually made the request for up to an hour with that employee as a favor to the union. Andrew, what would you say was surprising to you?
I think the most surprising thing to me was what happened in Michigan. I feel like in most states, in most cases, public sector labor reform is very incremental. It takes years to get from point A to point B. Michigan really just kind of upended their entire public sector labor law in roughly a year. And I think it kind of goes to show that everything can change with the political winds. And I think it really, reinforces, stakeholders in, strong states that protect workers and taxpayers. You always have to be ready for anything, really. And I think Michigan showed that everything can change like that.
Hmm. Maybe that's part of the impetus behind the Illinois amendment. That concept, while incremental for a state like Illinois, has also been introduced in Pennsylvania, in California, and in Vermont as potential constitutional amendments. Some of them have gained a little bit of traction, like Vermont and Pennsylvania, but would really dramatically take labor law in the direction of favoring union executives over workers.
All right. Do you expect any labor or union laws to play a role in the 2024 election? Like, will it drive voting in a state like Arizona or Pennsylvania? Could it influence anything like that? We're in this season, about 60 days to go. Any thoughts on the way that could have an impact, or what to look for maybe post-election in terms of union political spending?
Yeah, well, it already has. I mean, the unions have already been very much engaged in the 2024 election. And I'd say their influence is more profound at the local level. So as much as we like to talk about, Kamala Harris and Donald Trump, and I know that the unions have provided the type of manpower that only they could provide in both of those elections. So whether largely for Kamala Harris and against Donald Trump, but the type of manpower I'm talking about is staffing phone banks, going door to door, and small dollar donations. Unions have been very much involved in that. But I got to say, at the local level, think school board elections, county commissioner, that kind of stuff. Unions are even more powerful because a few $100s can make the difference sometimes in those elections. And the union endorsement, which is essentially free for the union to give, has been a very strong factor in school board elections. Yes, and they've been very involved already.
And looks like our last question has been submitted. If you do have a question, please feel free to submit that in the chat, and we'll see if we can get to it in the time we've got left together. But any insight on potential reform to how LM2 membership numbers get reported? Without the reporting of agency fee payers, it could be tricky to track true membership changes because the union only reports member numbers, not overall representation numbers that would include non-members compared to membership numbers. Any thoughts there?
Well, I'll say something about the LM2, but then Andrew, you might want to touch on, the other kinds of reporting that's done and the other ways we might look at membership numbers. Donald Trump during his administration did have some potential reforms to LM2s. One potential limitation to LM2s is that they only apply, because it's the federal government. The LM2 requirements only apply to unions that have some kind of an interstate presence. So if they're a local union that is almost exclusively local, we actually get no LM2s on some of those entities. So that's a huge restriction there. The Trump administration wanted to expand the LM2 requirements so that if they were merely affiliated with another union that had a federal presence, they would still have to file LM2s. There are also opportunities at the state level, though, to increase some of the reporting requirements. And some states have enacted reforms that require that kind of thing. Even states like there's a requirement in Connecticut that there be a bunch of financial reporting. The state basically doesn't enforce it. So yes, this kind of thing could really be improved. One of the ideas that came out of Florida that I didn't mention before was that Florida requires an annual registration from unions, and in this past legislative session beefed up the requirements so that unions would have to report true membership numbers of the type that you're talking about. Now, there are other mechanisms by which we can judge how many members there are in a particular union, and then versus how many how many people are represented by that union and would have formerly been agency fee payers. So Andrew knows a lot more about that than I could.
Yeah, I think that information is certainly accessible now. That we obtained it for our union membership report last year. And unfortunately, what you have to do is you have to do public records requests to the employer. So at say the state government level, this is a little easier. You submit the request asking for the number of employees represented by a union and the number of employees paying dues to their representative union, and that you submit that to the state's HR department equivalent. And they'll get that information. Where it becomes more challenging is, trying to get a full scope. You have to go at the local and municipal level. And, in Pennsylvania, there's 500 school districts alone. So the scope of the requests is very high. And it's very time consuming, but the information is available. And most of the time, the public employer is the one who actually has that information available.
And then one other thing, the Bureau of Labor Statistics at the federal level does some surveys of public employees, and from those surveys they can derive some membership numbers, including a percentage of how many people are represented by a union and how many people are members of the union. Again, it's a percentage, so as a percentage of the overall workforce, and those who are represented in general by a union. Those are, it's survey data. It's valuable in the sense that you can compare them year to year and get, I think, some meaningful trends out of it, but they're not super reliable in terms of the in terms of the exact data.
Yep. And one thing I'll note is in the chat, I did put the link to the union membership report that Andrew and David released back in March of this year. So again, that was it's called State of the Unions: Examining Union Membership in State Government.
And there we solved one of the problems that Andrew was describing. So taking a deep dive into each local union would be, first of all, it's a moving target. By the time you're done with, thousands of public records requests, all the numbers have changed anyway. So what we did is focus exclusively on state governments, and we looked at their membership numbers, so that we can at least get a proxy for how membership looks throughout that state.
Excellent. Well, thanks everyone for making the time to join us today. And I will be in touch again via email with the presentation. Feel free to contact me if you have any questions or there's any additional information that would be helpful for you. You can also reach me at 412-716-5437. And I'll, of course, include all of my contact info in my email to you. So again, thank you for joining us, and thank you to Andrew and David for authoring this report, walking us through it today. They're certainly happy to be interviewed. And if there's anything else that we can do in this area, just let us know. We're here to be a resource on all things labor and public sector unions. So thank you so much again. Have a great day.